June 24th at 6:30 p.m. I hereby call this meeting of the Howell Township Planning Commission to order. May we have a roll call, please?
Williams.
Present.
Spalding.
Here.
Newstead.
Here.
Bowl.
Present.
Francescos. Stanley.
Here.
Lolio.
Here.
Excellent. Thank you. Please rise and join us in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, first item up is review and approval of our agenda. It's a pretty short one today. We have a motion to approve or call for edits.
Mr. Chair, I'd make a motion to approve the agenda.
A motion from Mr. Vole.
I'll support.
Excuse me. Support from Mr. Spalding. All in favor?
Aye.
Motion passes. Next up is our minutes from our fire meeting. Do we have a motion to approve or any suggested edits or corrections?
I'll move to approve.
Support.
Motion from Mr. Spalding, support from, was that you, Tim?
Newstead.
I'm sorry, Robert?
Nope, Newstead, Michael.
I have a brother name.
We got you bracketed.
Support from Mr. from Mike.
From Mike.
All in favor?
Oh,
Aye.
Can I add one thing?
Of course.
On D, I noticed we closed the public hearing, but I don't see anything in here that it was open. Or was it just one public hearing?
Are you saying B?
On B, there was a motion by Mike, or whoever that is, to close the public hearing. But I don't see a motion to open the public hearing.
Well, I see it on A.
Yeah, there's an open and a close on A.
Yeah,
but there
we,
isn't-
yep.
Did,
You didn't do it.
okay. All right, I didn't want to open up a can of worms.
Okay, with that said, do we have a motion to approve? With edits?
You can't really edit it.
Okay, so it wasn't opened, but we closed it.
Right.
Does that mean we have to have another public hearing?
I don't know. That's a good question.
Okay.
I think,
Should I not read the minutes anymore?
no, we appreciate it when you do. I'd appreciate it if we paid more attention during the meeting itself to make sure we hit all the things, but yeah. I think honestly we're probably okay, and the reason I say that is you were considering the same thing, right? And so even though they were separate items, it was really one discussion. You know, it was one text amendment that we were discussing. So I believe we're okay to move forward as you've got it.
Okay.
Because weren't they on the? You're talking about B?
Yeah.
So there is a motion to move to close the public hearing. So.
But did we hear both
I know
of
there was
these
some,
at the same?
I don't think we voted, I think we were right into the second one. But under A, it does say move to close.
Yeah.
Do you have any thoughts, Grayson?
I was just saying, I agree with Jonathan. It didn't get reopened, but because it was essentially the same thing you guys were voting on, I don't
Okay.
think that would be an
It
issue.
was more of a continuation, I'd say, but that we close it, but not open.
Can we note that we recognize that, but also acknowledge that it was for a similar item previously discussed, or?
If you want to recognize it, I need to know what you want in those minutes.
I would recognize that the public hearing was not open, but was continuation of the first public hearing, since it was a related topic. But that's how I'll amend my motion if someone wants to support
I'll still support that, because I think that's the way it went down. You know, we were kind of under the assumption that they were both dealing with the same thing, so we just kept rolling through it. I agree with that.
Very good. We have a motion from Mr. Spalding, a second from Mr. Newstead. All in favor?
it.
Aye.
Motion passes. Okay, next up, we have our initial call to the public. This is your opportunity to express any interest or comments you have on our agenda or other township business. I ask that you keep your comments to about 3 minutes and, of course, be polite and civil. With a motion to open the call to the public. Do that?
So as we were kind of talking about before, but now we're all being recorded, I'm representing the Amber Oaks community, and I don't represent the neighboring community, although they're kind of tied into us in a financial state with the direct playground, et cetera. But their yards are even smaller than our yards, and so when it comes to putting in a shed, regardless of the permitting requirement for the $75, a foundation issue or whatever, those measurements, when you measure out the backyards, interfere with where that shed would go. For instance, in my house, if I were to go 40 feet off the back, the front of the shed would be 3 feet 8 inches off my house. If I were to follow the other rule, 10 feet off the foundation of my house, or the back side of my house, I would be, with the other side of the shed, 31 feet, so I would be 9 feet within that border. The other gentleman, Nick, who couldn't be here today, I told him I'd come speak. When we measured his yard out, it would literally put the shed in the middle of his yard, and it would kind of render the rest of his backyard somewhat useless, and it really interfered with basically family activities, et cetera, kids playing. Then if you look at trying to get a variance, that's a $400 request, and so then if that does get approved, you've added about a third more on to what the shed, including installation, would cost, depending on where you get the shed from. Maybe some people can get really fancy big things and put little mini bars in them, but just for a general storage shed, you know, you're talking I think it was about $1,300 Nick was looking at putting his in, and with an extra 400 plus the 75, you know, you're really taking a big chunk of money and making that cost a lot more for the residents. And I think this would affect many of the communities in Livingston County, and I am really asking you to kind of reconsider maybe the size of the property, or make a special exception for the communities with small yards that are, you know, either HOAs or non-HOA neighborhoods, where that really does put kind of a burden on the rest of the township. So that's my case, and if you have any questions, I'd be happy to answer.
Does your HOA have rules and regulations about putting sheds?
Yes, we do.
Okay.
They have to submit an art design, an architectural design, to the board. That goes through review with our management company to make sure they're within the bylaws, so they can't just nilly-willy put anything in. They aren't exact, but they are very close to kind of what the township says on height, size, et cetera, and, you know, color, and then we get into the specific things of color, advertising, all that kind of stuff that kind of mimics what the township does. So we are very aware of your regulations, but we have our own regulations that they have to go through. And frankly, had the process been a little quicker for our art designs going to the management company, he would have got this in prior to this change being made, but it takes a few months for that to go through our process.
Okay. In, more specifically, the setbacks. Are the setbacks from your HOA less restrictive than ours?
Oh yeah, we have most of the sheds in our neighborhood that are on people's property right back to the property line. If there's a fence there, they go almost right back to the fence, with just enough room to mow on most of them.
And that's kosher with the HOA requirements?
Absolutely.
Okay.
Yep. Any other questions?
Can you just state your name and address
Oh, yeah,
for a minute? Sorry.
Yep, my name is Robert Wentworth. I live at 3598 Amber Oaks Drive, just down the road in Howell.
Thank you.
Any other questions? No? Cool, thank you.
Thank you, sir. Appreciate the input.
Yes, sir, thank you.
Any other takers? Hearing none, we shall close. I'll call the public and move over to the zoning board of appeals report. We did not have a meeting. So, we don't have a report. And one for this month has been canceled as well, so I'll plan forward next time we meet. Township board report. Those minutes are in your packet. Tim, anything of interest?
Several things that I had marked out. There was a motion to dismiss a violation to the American Legion for their parking lot. There's also a resolution that was presented. That motion has been tabled currently pending legal review. Just of a note, there were pay increases for the township staff. I believe we ended up at 4% total. And of other note, all the elected members of the board declined any type of pay raise. So. Also, the Sayburn rezoning was approved. The ADU ordinance came back, which we are here to discuss later. And the rezoning for Mr. Jewett passed. And they've also posted an ordinance officer job position. That is on the township website, if you care to take a look at it. And also of note, Jonathan, maybe you could help with this, because you reported that there were procedures for the planning commission will be changing due to some cyber scams that are taking place. You could probably tell better than I.
Sure. So we found out that people that were applying to the planning commission were getting bills after the fact, signed by Wayne, actually, demanding payment, of a couple $1,000s. So in the past, what we have done is if you were an individual, we would redact your phone number, your email address. If you were a business person, we wouldn't. We kind of saw that as public, right? Like, for example, the Lepics were before us. He has a landscaping company. But moving forward, we're going to, on the short term, redact all of that information so that it's not available, because they are obviously going to our website and getting that information off of those applications that we put in your packet. And they're emailing invoices and that sort of thing. Long term, we're going to look at changing our form so that the thing that goes in your packet doesn't have to be redacted, but we'll still have a sheet that we get so that we're able to contact the individuals applying for things.
Good. Where were they directed to send these fees to?
Oh, you had to do
I
it.
haven't seen any of that one.
You had to pay by wire, so it should have been a big red flag. Yeah.
iTunes gift card to Bitcoin. Oh, that's interesting.
That's all I had, unless someone had any questions specifically.
Okay, hearing none, moving on to the ordinance violation report. I've also got the permit list, I've seen that. Is there anything of note on the enforcement list here? Any changes or new ones, would you say? Seems like we rehash a lot of the same ones.
Well,
Minor updates, visited a homeowner.
admittedly, it takes a long time to get stuff cleaned up, in my opinion. I wish it was a lot faster than it is. So that's why you see the stuff that we've done. Obviously, this report was pulled on 5/29, so you get the same one that is in the board packet. So it is a little out of date by the time you look at it, but it shows what we've done and what we're trying to do to get it cleaned up. So.
Can I ask them?
Of course.
I've been wondering about this for a long time. On the 2900 Brewer Road, broken down vehicle, farm tractor on a lot under 2 acres. We have an ordinance that says if you live on 2 acres, you cannot have a farm tractor. Is that how I mean, what if you are a collector and you just like tractors and you wanna have a tractor at your house?
You're out of luck.
Really?
It actually just says tractor, it doesn't even have to be farm tractor.
So if somebody's got a 1032 John Deere,
Yeah, what,
that they're in violation?
I mean,
Find
it's
that-
section
find that.
1424, if
Yeah.
you want to look at it. It reads, trucks and other equipment necessary to the function of permitted uses and activities on parcels of land of 2 acres or more, and then it goes on to tell you where it is, but it specifically calls out stuff if you have 2 acres or more. Anything less than that, because of how everything's, and Grayson can probably talk to this better than I can, if you don't have 2 acres, then you can't do that thing. And so when it talks about a tractor, yeah, if you don't have 2 acres.
Correct me if I'm wrong, though, wasn't this a grandfather clause with this gentleman or not?
So that's what we're working with Grayson and Paul on. I mean, that's what he said. He said he's been in the house, I think, since the 70s, early
Yeah,
70s.
Yep, I know.
And, you know, he says that he's had a tractor since he moved in. So they are looking at it for us to make sure we're going down the right path.
Grace, are you familiar with this one in particular? From the
Slightly, about to that extent, and I think that kind of brings up the bigger issue of working through the zoning ordinance as a whole again, because it seems a bit outdated. And
If this gentleman here, if his grandpa had a 4020 and he wanted it and he kept it in his garage, it just seems ridiculous to me. It just seems ridiculous that you can't have a tractor. You know, I'm sure you're not gonna be, somebody wouldn't be, planting corn in their front yard on 2 acres.
right, they're not plowing their front yard.
And like Grayson, like you said, if we're looking at stuff, when it comes, this just, I almost found it unbelievable that.
You're not alone.
Mr. Spalding, you actually described my dad, who lives at 1.73 acres, but he's elderly, he's like 74. He has a tractor, but he uses it for snow blowing because of the length of his driveway, and he also uses it for, some minor, like garden repair, et cetera, around his property, because he can't use a shovel, snow blower, any of that anymore. So, if that helps you with your decision making.
Oh, that's a very valid point. I'm on a private road and several of my neighbors have tractors. I use it for road maintenance and so on.
This gentleman
All my
does
5
too.
acres, but
This gentleman does too.
Yeah, I mean, you can have a
Cuts his
eight-end,
grass.
plow your driveway with it.
Mhm.
So, just a thought. So, it sounds like other people are
Could
thinking
you
about it too.
maybe expound a little bit on how that got worded that way? Cause I know it's called out specifically more than 2 acres, but it doesn't specifically say anything. It doesn't call out under 2 acres.
yeah, I would say that's probably a likely unintentional effect, similar to how we're revisiting portable storage containers already. And I think that this one went uncorrected because code enforcement in the township is as complaint-based, not proactive. So the code enforcement officer is not out looking for tractors on
2
acres
acre,
under 2, or on land under 2 acres. However, this does bring up that opportunity to correct the mistake, because I really do believe that it was just an oversight.
Thank you.
okay, moving on.
Hold on, Grace said an oversight as in how?
As in, they didn't also include tractors as something that is part of the language in parcels under 2 acres as well, but they explicitly call it out in over. So with the ordinance being permissive, if it's not listed, it's not allowed.
So when this was written, were the ordinances permissive? Because the way I somewhat interpreted that when I read it, and everyone has their own interpretation, was maybe it was meant for, maybe in the times when our community did a lot more farming.
And I'm sure it was, because I'm
And
sure that's the
when they
last
were-
time it was
They were referring
updated.
to maybe combines.
Right, and I'm sure that
Yeah,
was
like-
the intent of
Like
it.
tractor,
Right,
tractor,
that
it's
was
not,
the other thing, my point
not a
is,
yard
somebody's
tractor.
version, somebody's
Or
idea of a tractor is
compact
different from somebody else's idea of a tractor.
Right,
So-
which is why moving forward, the zoning ordinance should be as explicit as possible to avoid exactly this. Yeah.
Okay.
My lawnmower is marketed as a lawn tractor.
And between this internet
yard tractor,
thing,
garden
Mark,
tractor.
what do you-
You can buy a new one.
Yep.
Yeah, that was good, good.
Thank you.
Okay, next up, our scheduled public hearings, which we have none for this session. Number 11, we have other matters to be reviewed by the planning commission, which is also an empty agenda item, which takes us to business items, starting with the old business with the renewable energy ordinance. Grayson, what is, you know, I print this on a black and white printer, I know there's red ink in here, so I don't really know where that's at. So can you give us the highlights of what was edited and updated?
Yes, from the last time we spoke, this has not been edited because we chose to table it at the last meeting after you had your guest speaker come in. So the modifications are from that previous meeting, and they include updating the decommissioning definition to include restoration of the ground to its original condition. Credit's been added to surplus listed under the intent and accessory solar energy systems. And the planning commission can now increase or decrease the required setbacks based upon impact to the existing land uses or surrounding zoning of the adjacent properties using certain criteria, explicit criteria that's listed. And then the planning commission will now have the right to modify screening requirements if it's reasonably determined necessary. The planning commission will now have the right to require additional fencing or screening for security purposes when deemed necessary. And there have been modifications to section 16.15 to increase the letter of credit posted by the developer. And language pertaining to required studies has been amended to allow for more planning commission discretion. I also have a red line copy if you would like to review that.
Have those been incorporated? Cause they haven't.
Yes.
Okay, I saw a few of them.
Grayson, the one thing I compliment, I hope everybody noticed, that was the decommissioning focus.
Yes.
And just if you guys look on page 8, when it talks about the developer having the right, well, he's gonna put in an estimate, like every 5 years. I liked on number 4, where it said the applicant shall engage a certified professional engineer. So that has to be somebody that we recognize as being able to address this situation, so that was good.
Also on that page, Grayson, in paragraph 3, this needs to be a D, about midway through, the guarantee shall be increased by a minimum. There's no D there.
Oh, thank you.
Grayson, I had a question on page 2, under number A, intent. The last sentence, is this still a draft copy, I understand?
Yeah. Yep, nothing's been passed for
In
this
the
yet.
renewable energy overlay district where this special land use is permitted, this is a full sentence. Faculties for the capture, storage, and distribution of renewable energy for commercial purposes. I think, are we missing a connection of the or something in that sentence?
Yeah, it does look like that. Yeah, that does seem included.
And then moving on to page 3, and I didn't know if it was the way it copied, but it's the chart.
weird, yeah.
It says
Yeah.
2 right-of-way on the second page.
Yeah, it just printed weird for that
Is that
one.
what it
Just a
is?
Yep.
page break,
Is
I
there
think.
supposed to be distances in there, or
No, so that, goes for
should be
the
front yard setback?
adjacent to right
the
away.
right-of-way?
Yep,
Okay.
so that would just need to be,
Okay. That
page
makes
cut
sense on
there.
the copy. Then I had a question on page 5, number 8, on the noise. And it said the solar energy facility shall not generate a maximum sound in excess of 55 average hourly decibels. And I've heard this before, and I just wanna clarify it with us, is that 55 the average? So it can be a lot higher at a certain point and a lot lower?
Yeah, so that would, it would be the average, which would account for, uncommon, high volume noise.
So could you have
Occurrences.
like a shrieking for 2 seconds and then
Right,
like total
Absolute
silence?
yeah, and that would that would be the average.
Is that standard on how they usually word these?
That is standard on how it's worded, but we can also revisit it if you prefer, or if the commission thinks that it would be better
Right.
worded.
I think last time we were discussing what 55 decibels sounded
Yeah.
like, and I actually printed something off. It says a household refrigerator is at 55. And then like normal conversation is 60 to 70.
Is there 100 on there by any chance?
100,
Chainsaw?
actually I think anything above 70 or 75 is actually where it starts being painful. It's against your health. Let's see, closest.
I'm just saying it for our average, you know, if the average is 55, you know,
A
what's
subway
the
train at
top
200
end?
A subway train at 200 feet is 95. So, city
So-
traffic is 85, telephone dial tone is 80.
Well, might we consider, we have the, let's see, what about the average hourly decibels? Could we put something to not exceed X decibels?
Is that something that,
We could do that. I think another way to approach it was currently, it's at the wall of the nearest dwelling located, and we could do property line, because that would
That would,
include a few extra
I think that's when,
feet too.
that has been kind of the complaints with some people is the noise, the humming the
Right.
birders make. I think
That-
if one came in next to you and you had a running refrigerator in the middle of the night,
Yeah, I'd say that's also my understanding that that humming is actually measured differently, on a different weighted scale, but that's not typically the one that is regulated in this way.
This is just the panel.
Yeah, this is the like the noise of us talking, but not like the deep hum
okay.
that cause like the vibrations,
Okay.
from my understanding of.
So what is what would be an acceptable, and like you say, not to exceed? We had a suggestion for rewording it.
Oh, my suggestion is to say property line as opposed to the nearest wall.
But still keep the 55 average?
That would be my opinion, yes.
Oh, are these, I mean, they're not known for releasing occasional shrieks.
No.
Fairly quiet.
you would imagine it would be a steady noise.
Yeah.
But I just wanted to clarify that it was the average, so
Yes, it is the
It could
average.
be something that gets louder and then gets quieter and oscillates back and forth, as
Yes.
long as it doesn't go above the 55. But we can change it to the property line instead of the wall?
Yeah, if that's something you guys would like to do. It's currently at the wall because that's how PA 233 has it. So we tried to keep it as close to that when presenting it with you, and then figured we would adjust from there.
I like the property line.
I agree.
Probably, I agree too.
So if there's a roadway there and folks are, out walking their dogs or whatnot, it shouldn't be louder for them than it is 100 feet to the next house or structure.
And the next house could be 10 feet from the property line, or it could be 100 feet.
Right.
Right.
That's more restrictive too.
Yep.
Property line. But I'm okay with that.
And then also on the same page, under the wind energy, on number 3, the distances for the right of way shall be at least 2 1/10 times the blade tip height. I know we don't have any windmills, but just in the event that we did, is that pretty standard too?
Yeah, that again is also, I believe, actually word from word from PA 233. I can't really say how they determined that was the appropriate height, but
We've all probably seen videos where they've come apart,
Yeah,
right?
it is.
And like I said, we don't have any, I'm just kinda wondering if that was the standard. And then I had some questions on number D on page 7, standards for renewable energy facilities. And it says the township shall have the right to enter the site for the reason of repowering the facility. And this, I was wondering I guess I understand that, but it sounds like we're gonna be able to get into the power generating business. If you read this, cause it says charges, cause it says that the township, under certain circumstances, can go in and actually, charge them for the procurement of a contractor and the expertise to oversee and execute the entire set of repairs and or maintenance to restore the site to its original capacity, if there's any problems. Is that somewhat standard too? Yeah. I mean, I understand needing the protections in there, I just wanted us to be aware of it, that they were.
yeah, and I believe that's one more so for the protection as for just in case, as opposed to something that you expect will be happening.
And on page 11, number 20, it says the special use permit shall remain in effect unless they change ownership.
Yes, so that means that if the ownership changes, then that special use permit is null, and the new owner would have to come back and reapply to state that they're under the same rules, or they want to imply new rules that they're going to add into their special land use.
So is a special use permit in this case, is it revocable? Or
No,
does it stay with the land like
it's gonna
a
stay.
variance?
It would stay with the land like a variance unless the owner changes, and that's why it's specifically written here, because otherwise it would stay.
Okay.
And it's just to allow the township to have that opportunity again with the new owner to be sure that everyone is,
On the same page.
yeah.
I think that did it for me.
I did have one, question, Grayson, on page 16, this is in regards to ground-mounted solar energy system requirements. I'm kind of curious on, 5D, Roman numeral 5, at the very last one. If I'm reading this right, it limits if you have a ground solar array to 50% of the square footage of the primary building of the property. And I didn't know what the section 317 was in reference to, but I have a little bit of a concern if that's gonna be enough for a home to power a home. If you elect to go to a ground-mounted system. I don't know a ton about solar, but someday I'd actually like to have it at my house. And I'm not sure if this would be enough. I'd be able to put enough panels to cover the electric from my house. I don't know how this is calculated on here. How's this? Now, the 50%, I'm just looking at roof coverage. If you're not going to put solar on all of your roof, obviously, because of the orientation of your home. So if you've got a southern-facing house with a roof line, half the roof probably would be conducive to solar on there. So I kind of see how you're coming up with that. Whether or not that's sufficient or enough, you're kind of limited by the size of your roof. But I'm wondering if someone goes the ground mounted direction, you're kind of using that same limiting factor on a ground structure, a ground mounted structure. I don't know if that's enough. And I don't know how that 50% number comes up. I didn't have time to do some research, but I'm just kind of throwing numbers just in my head on solar panel sizes. I don't think if I wanted to put solar to cover all of my house, I don't think it would have enough capacity with that. But I have, and some people have, I have a geothermal heat system. So my house is pretty much 100% electric. So I'm not just covering the refrigerators, I'm heating, cooling, my water and everything. So I don't know how that is. I think that probably is not adequate. I'd like to see that number, some thought put into that, maybe that number increased. I don't want somebody to have their whole backyard in solar panels, but maybe that needs to be 75% or a different number on there.
So I thought I saw some language where the lot coverage for solar was 75%? Did I read that somewhere?
Yeah, there was,
The lot coverage, but not, I think you're talking about the building, correct?
a ground-mounted solar array to serve a home is, the size of it is limited by the size of the home, if I'm reading this
Yeah,
right.
50% of the square footage of the primary building of the property.
Yes.
Yeah, under accessory
So,
solar.
if you have a 2,000 square foot home, you can have, if I'm reading this right, 1,000 square foot of solar panels. Is that enough to power a home? I don't know.
I would say, from my understanding, it would be a typical home, but I would agree that with your home being almost completely electric, that would cause issues. And that I don't believe that it would, be able to cover a home that way. So if you think that there are a significant amount of people that would make it worth, upping the number to 75%, I think that's,
And the way, I don't have a real great knowledge of solar and how it's work. I actually talked with a buddy of mine at church that has that, and you know, the way DTE is now is you can't profit from solar. You only can get a credit for what you, so it wouldn't behoove somebody to be generating 3 times what they're using, because they would just amass a huge credit that
You'd never be able to use it.
yes, so I just wanna make sure that this meets the requirements of somebody who doesn't wanna put it on their roof and who wants to put it on the ground, yet generate enough electricity to cover their needs. And
I'd say for that matter, if you don't think that it's a necessary provision to have, this is for accessories, so it's not under PA 233, so you guys have all the discretion with this.
I do think that we wanna have some kind of limitation, cause I don't think we want somebody to put like 40,000 square feet of power of solar on their house.
Grayson, are solar panels different? Like, can some panels generate more than what other ones do? I mean, I don't really, I'm not familiar that much either about it, but I just wanna know, is there this grade, this grade, this grade?
I think it's newer versus older.
Newer version.
The
But
technology.
they also tend to have a deficiency in the amount of electricity they produce. It's not maybe significant, but somebody may wanna size a unit up to know that 15, 20 years out, if these are 10 or 15% less efficient, they're still meeting their needs on there. I don't know, I can look into and do some research on this, but I wouldn't wanna limit it to somebody so they couldn't serve their needs. That's why my question is, how do we come up with the 50%?
Can I help you with the solar stuff?
Yeah,
So I have a 2,500 square foot home.
I'm not the chairperson.
Well, you guys are talking about, I have a 2,500 square foot home. In order to power my house with 10,500 kilowatts, I need 18 panels with the current technology. And that would bring my bill significantly down. I'd probably pay $2 or $3 a month. But I also don't have enough roof space to put the 18 panels up, and I have a southward facing home. I have a roof that faces southward. So to answer your question, to power a 2,000 square foot home with one of those ground panels, it depends on the size of the ground panel. The size of the ground panels are different than the size of the roof panels. And the roof panels, the last time I looked, produced about 502 kilowatts apiece. So
I think, thank you. I think we just need to put some more thought on here, to not make it real restrictive, but still have some kind of restriction in there. Because somebody would not have any course of action if they were limited by this.
Yeah, the people that are installing it say you need X amount, and the ordinance
Yeah.
says you can only have Y.
Yep.
So is the thing you want Grayson and Paul to work on is to figure out how much a house uses, how much area that takes up? Is that the goal?
Yes.
Do you put something in the language that says up to 50% unless you can show that you need more? You know, the person that they're putting, and you can come and get a variance to that ordinance, because you can prove that you need more coverage to power your home.
But didn't Robert didn't he just explain that there's a difference?
Well, right, so that's what I'm
Yeah,
saying,
so
you
I
set
guess-
that
yeah.
hard line, and then the people who are gonna come install your solar panels say, well, it's gonna take this amount. And if it's 52%, can you come here and get a variance to that ordinance that says, yes, you can go ahead and put that amount in?
Or unless you have like a hardship that you can present, or.
I think if we had just had maybe a generous percentage of your square foot of house, that would more than suffice a resident's needs. Maybe would be.
So this.
Yeah, and I'm fine with that, but what's the number?
I don't, yeah, I
You know,
don't
that's, I
know the
mean,
number.
and is it,
But I think that the 50% is on the low side, on there.
Well, do we have anything that addresses maximum ground coverage? I mean, if we increase to 75% and that fills my backyard with solar panels.
So, yeah, the next thing that's mentioned there is section 3.17, and that's the
I thought maybe
ordinance.
it was covered in 3.17, so that's the next page.
What does it say in 3.17?
Well, that's the schedule of area height, and setback regulations for each district.
Okay.
So we could remove the percentage if you want to just go off of the standards that are already in place.
Could we hold on this and just contact like a solar panel
It-
company
that-
to have us explain what the different panels are and what we can, I mean, I think we're kind of playing with something we don't really, I don't know much about solar panels, but I think that if you talk to a company and they can explain the difference of a roof as a ground, as a,
Yeah,
I mean,
or,
yeah.
I've got a 3,000 square foot home and I'm using
Right.
and I have geothermal. I know what my electric bills are. I know how many kilowatts I have. I don't know if I was to ever go out and get solar. I don't know how many panels I'm gonna need. I might need, 100 of them, or I might need 20 of them. I don't know. But I wouldn't want somebody in whatever situation, if the house was bigger or smaller, have a restriction where, hey, we wanna pay for all our power with solar and not be able to do that because of something that we've done. I don't want them powering the whole neighborhood or being able to have twice as much as they use, but I don't want to.
Well, that's the thing, though, you have to assume that they're gonna become more efficient as time passes. So if we set something in stone today, then in 5 or 10 or 20 years, those solar panels will power the neighborhood instead of just the house.
Possibly, yeah.
Potentially.
And this
Yeah.
is just for ground mounted solar. So this
Yeah.
could be in addition to if they wanted to do the roof, and building mounted. I'm not sure.
Yeah, because I think
different parts,
if you went with a roof mounted, you're kind of limited on your home size for that, unless you put them on a barn.
Well, this one actually is dependent upon your home size too, right?
Yes,
So you
it
could
is.
have 10 acres and have a 1,000-foot square house and not being able to put only 50%, right?
Yes.
And the 75% is for a storage energy facility, so we allow 75% lot coverage for a storage energy facility, but this is dealing with residential, I'm assuming, right?
No.
I don't think we should do it by the house size.
So Grace, when you're saying remove the 50% number and then just go by the property
'Cause
setbacks?
your neighbor doesn't want to.
Is that, and then that would pretty much
Yeah, and
take care of the, I mean, then you
Yeah,
can
because they're
go up
also-
to,
Maybe 50%.
because that still applies, right? The set, you can't go with that outside the setbacks. So if you
Yes.
took that 50% number away,
and it would still be under the same regulations as an accessory building or accessory.
My opinion is I think we need
So-
to have some limiting factor. Let's not take that away, but maybe put some thought into it. Maybe that's 75, maybe it's 100% of these. So you're still limited what they can put, but maybe increasing it is gonna allow anyone to do anything that they want.
Yeah, I would recommend to keep some percentage, even if it is the 100% like you're saying, because I agree, it's better to have the safeguard in place.
If we need to change it, shall not exceed the square footage of the house.
Which would be 100% of the square footage of the primary building. I'd be okay with that, but I don't know if that's a good number too. It's certainly better than the 50%. And if somebody had, I mean, if you just do the math, if somebody had a 2,000 square foot house and we said 100%, they could have 2,000 square foot of panels mounted in their yard. So what number is that? 10 foot by 200 feet? You know, or I don't know. That's that number. They still have to follow all the other rules on there. I think we need to put some thought into it so we're not picking a number that's gonna be too big.
I have a question for you, Grayson. You said section 3, the lot coverage, so if you're in the AR district, you get 20%, right, maximum lot coverage. But then you said it's the same as accessory structures.
I misspoke. It's an
Okay.
accessory use, not accessory
Okay.
structure.
All right.
Okay, do we have any other questions or feedback?
What do we decide?
I think I might call a solar panel company and just say, hey, look, I have a 2,000 square foot home. I want to mount some solar panels on the ground, and how many panels do I have to do that? And bring up the 50% and just see what they say.
And
I mean, this can't be,
Well, honestly, they're probably gonna ask you what your electric bill is.
and. and
I'm
what you- like
gonna
your
send them
case
to
is-
you. I mean, you seem to be the popular one, everybody's
You
trying.
know, with the geothermal, your case
So
is
can we do it on
much
lot
different than.
size? And not go beyond 100% capability of what what's the size of the home? I hate to limit it by because houses come in all different sizes.
Yeah, and electric usage could be very subjective
Sure.
too.
Right.
I'm on that.
But not to exceed 100% of that residence, whatever it happens to be.
Are you
Would
talking,
that
are you
work?
talking about
Like the
usage, or are you
average
talking about
usage,
size?
like-
The usage, like, but let's say they had 10 acres but 1,000 square foot house. So 100% of what, you know, obviously if we did 50% lot coverage, you don't want 5 acres of solar panels to do 1,000 square foot house, but could you do 100% of that house? So lot coverage up to 50% or up to 100%, but not to exceed whatever the requirements for that residence was?
Of the house, you mean?
Yes, of the house that was on
Yeah.
that parcel.
I think limiting it by the size of the structure, and if we're using primary building, and we're talking about the house. If somebody has a pole barn, you know, there could be a chance, somebody could have a pole barn and have a geothermal system that is just massive, or a second one for their pole barn too, and be using a lot of electricity. I'm sorry, I won't read the packets anymore, I'm sorry.
No, we should.
Absolutely.
But I don't know if,
I agree with you, I just was
Yeah.
trying to figure the best way around it,
What's the-
or the best way to address it. And
I-
maybe it is better that we wait and see, you know, maybe what.
I'd be inclined to
Solar
increase
panel.
that number, but I don't know if we wanna willy-nilly say 75% or 80 or 100, if we're gonna be grossly off.
I agree with all of you in that it doesn't make sense to me to limit it to the size of the house. If I have a small house, but I keep it at 90 all winter, my bill's gonna be a lot higher than if you keep it at 60. So to go by use is tough too, because if I have a fleet of electric cars in my garage, then my bill's gonna be higher than yours that
Yeah,
don't.
that's another, what if your
So-
whole family drives
Yep.
electric cars? That's another good point.
Well, these are valid points, but I don't think we're obligated to accommodate exceptional circumstances. I mean, if you've got 15 Teslas in your garage, go buy a bigger piece of dirt.
Well, you'd have to build a bigger house. It didn't matter whether you're on 2 acres or 100 acres, we're limiting it to how big your house is. So if somebody wanted to add more solar of it, that exceeded 50%, the solution would be you need to add on to your house so you
Well,
can get
we're
more
also
solar.
talking about how much of the square footage of your property is being covered by your primary dwelling structure and the accessory building, if you will, of the solar panels, to kind of limit the possibility of mini solar farms being installed in the neighborhoods.
But, and that is also, we're also controlling that too on lot coverage.
I will admit, in a recent ZBA case that we had, it takes a lot to get to your lot coverage.
Yes. Is there urgency on this?
Yeah, I was gonna suggest perhaps we wanna postpone until we can get some more info on what current output of ground mount solar panels might be. And I think maybe, there's probably a way to hit utility companies and see what the average residential bill is and the zip code. Maybe.
I think a solar company would probably know that.
So I will contact the solar
Yeah.
company.
Yeah,
1,
there.
2, 3 of them? How many do you want me to call? I will do that.
If you have questions, I can help you or talk to you about it.
Okay,
If you-
perfect. Yep.
I could even, yeah.
Okay, if there is no further discussion, we entertain a motion.
I'll move that we postpone it till the next meeting. Yes.
I second that.
Okay, we have a motion from Robert, a second from Sharon to postpone action on this proposed text amendment for additional research and information to be reviewed. All in favor?
Aye.
Aye.
Grayson, are you set with those? You have them all?
Okay, next up is our accessory dwelling unit ordinance. Hey Grayson, what's new or changed here? I can see administrative review rather than special land use.
Yes, that's the major change that was requested by the Township Board at their May 12th meeting. And they requested that the Planning Commission review the ordinance to determine whether any additional standards or requirements should be added in light of that change. Otherwise, no changes have been made to dimensional design or occupancy standards.
So, Mr. Chair, since I was there, the biggest concern was to have it a special use was the cost associated with coming before the planning commission, which is a really valid concern. So I was wondering if maybe we could get a breakdown on, just a rough figure, Jonathan, on what it actually cost for an applicant to come before the planning commission? Because there was a concern whether or not that could be modified the cost for something like this situation?
So you want to understand how much we actually expend when someone comes to the planning commission?
We, or does it come out of the applicant's pocket?
I mean, applicants pay to come here. Your question, though, is what does it cost us to have them come here to make sure that,
How about both? We're to the whole cost here, so I mean,
Well, one quick thing though, it says it's permitted through an administrative review process rather than a special land use. That doesn't specifically say a review by the planning commission.
Special land use must be reviewed by the planning commission, and the cost for.
Rather than a special land use, so it's in place of.
Yes.
yes.
Yes, so this will
the
just be.
issue with the township board, and it failed pretty heavily, 6-1, it got kicked back, was the cost of coming before the planning commission
For the special land use.
for the special land use was prohibited to the residents. And I don't know if we have those, I mean, just rough figures, I mean, you don't have to be exact.
A special land use permit costs $750
Okay.
just for the
Just for the
application,
actual-
not to get told yes or no to it.
And Grayson, the number 10 on the ordinance, basically zoning administrator, someone comes in with all that information to do an ADU and presents it to Jonathan. If that is satisfactory, he can issue a land use.
He must issue
He
it.
must, and they are good to go at least at the township.
Yes.
Okay. That was the change, that's the change. in
That's
the
the
minutes. Okay.
So I also noticed, compared to the other one, there might have been some, on number 7, it went from parking for a minimum of 3 vehicles, and it used to be 4. The one that was presented to the township board, I think, was 4.
Yeah, I think so too.
I also think so.
And there was also, there was a legal instrument that memorializes with the deed that was maybe taken out of the new one too.
I didn't think that one
But
was.
wouldn't that have been negated, Tim, because it has to be a direct related party? And
We did that in order to, like when the property was sold, so the new owners coming in would know that that wasn't to be rented. And it was in the, I don't think it's in the proposed, correct, that we have tonight?
Yeah, I don't see it here.
don't see it either.
But we can get that added back in.
Was it in what you guys looked at?
Yes,
the meeting?
at the township it was.
That, okay.
Yeah, I compared the 2 ordinances.
So when it got kicked back to us,
That got you
it got amended.
omitted,
Okay.
and the car change.
Yeah, I agree with that, the car thing, because it's talking about off-street parking, of 3 cars. It sounds like that's for the whole building, including the ADU.
Right, that's my interpretation.
Okay, so we definitely want to have at least the 4 there, I would think.
Do we know why that would have been changed at all, or just oversight, or?
No, I believe that was just oversight.
And was there a reason to hold out the,
I think I was going under the assumption that Mr. Spalding was going under, that it would be included, and because it's not a special land use, I thought that would be not as appropriate, but it can still be used.
I think because we had a lot of discussion on this whole thing for the longest.
And I can still take
Yeah,
exactly
and
what it was and put it
was
right
the
back in.
issue of how do we, once the houses get sold, how do the new owners become informed? And that was the reason to have it on there. Jonathan, you're still figuring over there, is that numbers?
I wasn't doing numbers, no. I was writing your comments down.
Are we just at the 750? Is that what, was that the cost? I mean, because we talked about modifying at the township board level. I mean, how would that be done? Can it be done? Could it be made any cheaper to do?
So I think part of the struggle is gonna be, I haven't looked at our fee schedule for a special use. He said it's $750, I trust him. The question is, how much do we spend to do that, right? So it's a little trickier. If you're doing multiple items that night, then all of your pay shouldn't be counted towards that, right? If it's only this meeting and we're only discussing this special use, then yeah, the cost of all of your pay to be here and Grayson's pay to be here, my pay to be here, right, that adds up.
Pardon me, Jonathan, would that be a special meeting called just for that, or if it just happens to be the only thing on our agenda?
It would just, I mean, you pay $900 to have a special meeting, so that's over and above whatever it is you're already paying for.
So if we had 3 applicants at a planning meeting for special land use, each of them would be paying $750?
Every applicant for their plans pays $1,400 to come before you. And then
Right, yeah.
they put money into an escrow account that when we get the invoice for Grayson and Paul's review, we get the review from Spicer, we pay those bills out of their escrow account.
So that $750, Grayson, what does that cover?
The application and review.
For,
And then the meeting.
From your,
Yes.
from your planning. So for something like this, would it have to go to yours? If it was
For-
an ADU?
As written right now, no. As a special land use, yes, and it would have to go to the township board.
So as a special land use, what makes it have to go to the township plan? Because I mean,
It's how it's written in the ordinance, and we have to write the review on if it meets the special land use requirements, and then that's what goes before you guys, and then if you recommend yes or no, then it has to go to the township board, and then they approve. Exactly what just happened on Hydraulic Drive. That was a special land use, that was here, and then it just went to the township board, and they also approved it. But the motion that's in the minutes here too, they go through each of the special land use requirements that needed to be met, and that's what the decision's based on. And really only that.
so that would be the only thing that the planner would actually review on an ADU.
And to assure that what's proposed will meet the zoning requirements, setbacks, everything else like that.
So the township board was also, if they sent it back here in case there were any other additional guardrails that weren't in the ordinance that we felt should be put there. I felt strongly that the applicant should come in front of us as 7 different people. That's no secret. I still believe that because I think we're putting duplexes in single-family residential areas, whether it's agricultural and I think every situation's a little different. I think we've tried to get it as close as we could with the guardrails. But if there's anything that anybody sees that needs to be added, because now it will probably be an administrative review and it'll be pretty much given with, if they meet the requirements of the ordinance, it's gonna have to be approved, so.
Well, I want to weigh in, you guys. When this passed, I thought it was a little bit onerous for people. If this is really about your elderly parents or your children who can't afford a house, there are plenty of houses out there that have a basement and they remodel it with a bedroom and another bathroom, and so I don't feel comfortable with this. I think we should, people have expressed a concern about taking care of their parents or their children. I don't think we should be adding extra fees or fines on them because they want to do that. My opposition to ADUs was having another rental unit in somebody's backyard where I don't know who those people are. It could be rented and they're not my neighbors, and then so I expressed my concern pretty much about having it detached. But if the purpose is for us to allow people to take care of their parents or their kids, I think that you go and you say, hey, look, I want to, we don't have to weigh in on it. Jonathan or whoever can weigh in on it and say, look, I want to remodel my house and I want to put a bathroom and a bedroom downstairs. I don't think people should have to come and pay extra to have that kind of ability to take care of their family members in their home. That's just my opinion.
think the tipping point, and correct me if I'm wrong here, was the addition of a kitchen. Putting in a bedroom and a bathroom, and that's just an addition to a house, it doesn't really matter.
So you put a wet bar in and a little microwave.
I don't know if we
They can
ever
do that, I
did.
see it
We
done all the
never- we
time.
never got the
did
tip-
find out
nope.
what the tipping point was.
Yeah, we never
right,
did find the
because
official.
It's just like Sharon says, I mean, if I put an addition on my house,
You're not coming here to
it's
sell a house.
subjective to the zoning administrator, correct me if I'm wrong, whether or not that makes it a duplex or a separate living quarters, correct?
Currently.
Currently.
And what's a kitchen? A mini fridge, a microwave, and
Yeah,
a
what didn't,
hand sink?
Yeah, hot plate, right.
Yeah, I agree with you, Sharon. I think that, I think as long as we're getting this information, Jonathan is reviewing it, issuing a land use, we have a record of where these ADUs are. I don't see someone coming here and spending $750 to get our blessings. That I think the way we've got it set up, Jonathan can represent that. To address having, there was something in there before of you had to record a document or something. I can see a problem, Tim, with maybe somebody using these as a rental, possibly in the future. And I think we just kind of would have to deal with that. I don't know if having a recorded document informing the new owner that they can't do that, I'm not sure how effective that would ever be.
Pertaining to rentals, though, if you have an attached or internal ADU, is that just kind of like having a roommate who helps pay the bills?
I think I think we put enough restrictions in here as best we can to keep these from turning into rentals. By having them attached, limiting the size, they gotta share common water, septic, and electric. We've put restrictions in here that everything can always get abused, but I think it's gonna be harder to abuse these than what.
See, if you have someone living with you,
Yeah.
your standard of who you allow to come into your home is gonna be a little higher as compared to me throwing 1,000 square foot thing in the backyard and saying, give me $500 cash under the table. That, I don't know who those people are, and I don't know how that will work, and if there's a problem, then you enter into a whole legal matter that is, I told you, I talked to law enforcement, and there's a problem. But when you invite somebody in your home, and really this started out for a way to take care of your elderly parents or your children, then that's what I kind of wanna try to make sure we can accommodate. So, that's
Yep,
just my thoughts.
having somebody in your basement or in the bonus room above the garage or right next to you, you're gonna be concerned about that. You're not gonna-
Absolutely.
yeah.
I don't disagree, and I don't want an additional expense on the applicant either. That's why I inquired if we could limit that somehow. I don't think we can. Obviously, enforcement is gonna be an issue 10 years down the road, 15 years down the road. So the document that was gonna be attached to the deed, the way it was written, I don't know exactly. A mechanism or legal instrument that memorializes that the ADU cannot be rented must be recorded within the chain of title for the property and reviewed by the township attorney prior to approval of the permit. I thought that was important to be in there for enforcement if it does become a problem 10 years down the road, when the house changes owners.
Quick
They-
question.
Go ahead.
So with number 8 here that says leasing or renting an ADU is not permitted, if Jonathan puts that right on his land use permit with it, wouldn't that be a document that would,
Until
be a
the-
record
until
of the
is
house?
sold.
But it'd still be a township document that
Sure,
would be with that particular property?
but if there was
That
a new
we would
owner-
have something to go back with, or the township would.
Right.
But I do understand what you're saying, if I buy the
But
house
the
from
own-
you and you don't tell me,
The current
so.
homeowner wouldn't know.
Yeah, that's right.
right?
Yep.
So I mean, I think that was the reason we put that in there. So they would be aware of it if they did decide to rent it out to a non-family member. So,
What if
Well,
we
even
put it
if
back
they
in?
were to choose to
Hmm?
rent it
Let's
to
just
a
put it back in.
non-family member, this is within the four walls of your primary residence still,
Yes,
Yeah.
yeah.
you know?
and that-
You could rent your basement out to a guy from church or a guy from your work for a year that was hard. You know, I'm sure that's probably goes on, you know, but if it ever becomes a problem, then now we have an ordinance that at least gives us a little bit of teeth in that.
Yeah, this is really addressing trying to, people building a mini apartment in their house for renting.
But it serves the needs of somebody who has a college kid or an elderly parent
Family
or
members.
a handicapped son or daughter that wants some independence, but you want them close by and.
sure, and we've
Yeah.
talked about this.
Yeah.
Regurgitated this, we don't know how many times. We're all in agreement with that, right?
Yeah, it's,
It's what happens 10, 15 years down the road that we've always struggled with. And once we open Pandora's box and make a duplex, the next owner, we're not talking about the current owner, or when that parent ages out, we've been through all this, we don't need to.
But I don't, Tim, I don't see this as allowing duplexes. I own duplexes. I don't see this as Howell Township is now allowing duplexes. I don't see it. I think we're accommodating family needs now. I don't see it as a duplex. You can't rent them out. It's for a family member.
Well, can we add a requirement that there be a accessible door between the ADU and the primary residence? Is that in here?
Was there something about a door? Yeah, ADUs are permitted to have an additional entrance point or to share a common entrance point with the principal building. So, I think that serves however anyone wants to do an ADU.
Well, right, but if it's or share a common entrance point with the principal
So you
building,
gotta be the or.
then you could have a wall separating that addition from the primary residence. Or if you take that and share, well, we have to rephrase it, but you made a requirement where the ADU has a entryway into the primary residence. I think that kind of kills the duplex argument because it's not two two separate living areas that are only accessible through exterior entrances. Follow me?
Yeah.
We've discussed that somewhere in the past.
Yeah.
I don't think you just wall up that door once you build it.
Right.
I think we need to leave the option for an entrance point to an ADU up to the property owner. Because you could, depending on how they wanted to put it, it probably makes sense to have, in some cases, to have a separate entrance.
if
And
it
in
needs
some
to be
cases-
zero barrier or whatever,
Yeah.
different requirements.
Exactly. Somebody could, we need to have a door here because the topography of the property allows us, we can get right up there on that.
So, after hearing how much it costs to come before on a special use, I'm willing to make it not come before the planning commission. So we get a permitted use or a permitted special use. How would that be permitted special use? I would like the document put back into just for extra added teeth if there is a problem down the road. I don't know if that makes a big difference with anybody. I don't know if that creates an undue expense. I don't wanna
Yeah,
create an
what-
undue expense for an
What
applicant.
does that cost? Does anybody have any idea what something like that would cost to get
Is that
drafted
what-
up?
Matt, did you?
It
get
was
that?
in the original ordinance.
A recorded document.
He's
that?
talking about when the permit was
I was just talking
issued.
about the land use permit that Jonathan's gonna issue. If he has that verbiage in it, you know, if that would follow the record of the house or the property, you know, this land use was issued on such and such date, and it has this clause in it that you can't rent out that portion of the property or lease it.
So if someone comes in and gets a permit to put an ADU in, and it's on the land use permit, they live there for 10 years and sell the house, will the new owners know?
Well, I would agree with you. If you're trying to alert the people who are buying it to say this can't be rented, the easiest way, I don't know if the easiest, the cleanest way is through the deed. So that you would find that when they do that search, that's gonna come up and you're gonna have that. Yes, it will be a record that, hey, 10 years ago, that guy pulled a permit for that and you can't rent it and our ordinance says you can't rent it. But people aren't gonna look there until you're probably already really far down the line.
That would be like a deed restriction
It would be.
on
Let's just put that back in.
I would support that.
Yeah. I'm fine with that.
And to answer your question, I don't know what it would cost. What I would do is if this passes, I would actually go to our attorney and say, draft me a deed that I will use as a blanket. I'm paying for it one time.
Yeah,
And then from
boilerplate,
then
this
on,
is-
when they come in, this is the thing that you have to, we're gonna fill out. And, you know, you're gonna pay, the fee is right now $30 to get it recorded. So you're gonna pay $30 and we're gonna record it to make sure it's recorded.
So the big issue with the township board, and John, you were there, correct me if I'm wrong, was to make it not a special use where they didn't have to come, incur the expense to come in front of the planning commission. And if there were any guardrails, I think the deed restriction was supposed to be in there anyway. That wasn't a request to be removed, correct?
Correct.
So that was in our original presentation that we've already pushed through. So those were those two things. So I think if there were any other guardrails that anybody would like to add to this, besides what's there, and I just pointed that out because I noticed that it was missing from the original.
That,
Can you read that, Grayson, just that part that was omitted?
I
Or do you
don't
have it?
have that right in front of me, but I can find it on my computer quickly, unless you have that, because I think you read it already.
I gotta find it again. A mechanism or legal instrument that memorializes that the ADU cannot be rented must be recorded within the chain of title for the property and reviewed by the township attorney prior to the approval of the permit. So we've already hashed that part out.
I don't think that would be too onerous to a property owner, and it would be, when somebody did a title search, that would show up if it was a recorded. Okay, I would be okay with that.
Doing it the way you described, sounds good. You know, this is our set form, this is how you do it.
So somebody wouldn't have to go to an attorney, you
Yeah.
could say, you need to file this.
It would be, we're gonna fill it out with your information.
Okay.
And then we're gonna go file it. You're gonna pay the $30
Okay.
or whatever that fee is at the time. And then we will file it to make sure that it gets done.
I think that seems
Yep.
reasonable.
Seems reasonable.
I think
Yep.
that's.
So for this one, because it's already gone to the township board and you guys have discussed it, if you wish to, you can make the motion to approve to the township board with the conditions that that's re-added in, the parking spaces changed to 4. And I believe that was the only 2.
Yeah.
That were needed.
Does anyone have any other?
So, but it wouldn't need to come back here per se.
Okay, if we have no other feedback or input, might we have a motion?
Mr. Chair, I would move to approve the AD ordinance as presented as a permitted special use with the corrections of adding parking spaces from 3 to 4.
Sorry, it's not going to be a permitted special use. It's going to be, you could say permitted through
Administrative review.
administrative review process.
Permitted through administrative review?
Yeah.
Correction of permitted administrative review with the added parking spaces and the document for the deed that we've privately
Yeah.
discussed.
was gonna say, that's what's gonna be written.
Support.
I have my notes, but, okay, I just wanna make sure that you guys are good with that.
Okay, we have a motion from Mr. Ball. Support, was that you, Robert?
No.
Yeah.
It's Mike.
Mike? Well, I could've sworn it came from us.
Maybe the acoustics in the room.
Okay, a motion from Mr. Ball, support from Mr. Newstead. All in favor?
Aye.
Motion passes. Thank you. Next up, we have our storage container ordinance. Grayson, I can see your summary on the front page here has looks like 4 bullet points. And I'm seeing some strikes. Any highlights for us on this?
Yeah, I would just
Or
say,
areas of interest, I should say, too, right?
yeah, we really were revising this, kind of due to the recent application for the outdoor storage, facility. And so we wanted to make sure we were regulating separately from, residential, commercial, and industrial. So this is going to do that, and, it kind of highlights the points you guys discussed in your last meeting, really. So, we added restrictions for the districts that will now be able to permit more than 5 cargo containers. They're still limited on the accessory building standards, as we discussed last time. And for office, neighborhood, service commercial, and regional commercial districts, we limited those to no more than 2 containers on site, and they must have 1 acre of land per container. There's also the option now that in certain circumstances, the planning commission can approve an increased number of containers if certain conditions are met, and that is kind of to allow for those special cases like we experienced. And we did address outdoor storage facilities in this as well now. I'd also say that I believe that with these changes, that would address the comments that were made earlier about the restrictions on the sheds in residential areas.
Could you specifically point where that one is?
Yeah.
Or does
let
that
me-
address that?
That's how I was.
I was gonna
that's
say, I was
why
reading
we're
through it
here,
earlier, and I
right?
was like, I
We're
think that,
dealing with this.
Does it answer?
yeah, so now it is split so that if you go to page 7,
Okay.
accessory buildings are handled themselves, and then cargo container standards are listed completely separate from. They're still very similar standards, but they are listed as their own item.
So this would actually move accessory buildings back to what it was in residential areas?
Yes.
But it puts the containers in their own,
Yes, and
Zoning.
they're still under
okay.
accessory buildings, but the accessory buildings won't be connected to those requirements now.
So will this, cause also when we changed that, we also changed where you could move it to the front?
Yes, and
So
that
did
is
that-
addressed in here too.
Where did that, I mean, I don't, we didn't get a chance to look at that one, but. But it is still allowed to put an accessory building that, as we discussed it before,
Yeah.
right? I know
Yeah.
that-
Right here, the front of the property,
Okay.
if it meets.
Grayson, where are the setbacks on, in here?
So the setbacks are going to go with the accessory building setbacks now.
That's not in here though, right?
Correct, because it's under accessory buildings, it would still be, it would have to abide by those rules as well.
Okay. And is that gonna address the concern that was brought up to us?
It should, yes,
Okay.
unless you're reading otherwise.
What concern are you talking about?
This
The
setback
sheds
in,
and Amber Oaks.
With the shed.
The
This,
sheds.
this does not address that.
It does, okay.
Didn't you just say that addressed it?
Which part doesn't, or what, sorry, where could you?
So section 1407 still says that sheds need to adhere to the ordinance.
And the reason we were talking the 200 square feet was because an 8x20 storage container was 100.
Yeah, and
180.
under 200 square feet isn't regulated by the building.
Right.
Okay, so Grayson, does this address the problem with, does this,
Looks like we
does
would.
it make Amber Oaks okay? Or
Mm,
or do we
so-
need to fix that?
So the way I'm reading this is on page 6. Because it says we will modify section 14.07, and then it lists what 14.07 is currently. And so the bottom of page 6 and the top of page 7.
And that's specific to subsection B, which is the detached accessory buildings and structures. Those are the requirements that would be under.
Right, so I mean, it starts with A, where it talks about basically it needs to follow the ordinance, then subsection B says that they shall be located entirely in the rear yard outside of the side or rear yard setbacks, which is the problem that they're having at Amber Oaks.
And that's for parcels over 2 acres? Because you're looking at 2, right?
So, I mean, most of the parcels in Amber Oaks are a fraction of an acre.
Gotcha. Okay, so
Yep.
that would need to be addressed here. So this is how that's one of the changes we had previously made to the,
Right, so it was
the
approved
original.
before, we made the change that sheds have to adhere to the ordinance, including not being in a setback.
do you remember what it was before, off the top of your head?
It was worded so that if it's 200 square feet or less, then it didn't need to comply with the ordinance. And so, I mean, the way that was written, it was interpreted that it didn't need to be outside of the setbacks.
I see, and we switched that when, I see.
Was there any requirements about not having a board foundation?
Before, that was a requirement in order to get that. If you were gonna put it on a foundation, then it would still have to meet the ordinance,
Right, okay.
whether it was 200 square feet or less.
And if you all are comfortable with that, I believe that that would be an appropriate change to make, as what we were intending to address with that is being addressed in just a different section now.
I think it was the specific cargo containers, right?
Yeah, which is now has its own section, so it doesn't need to be included in this area, which would allow for the sheds then. And I'll change the wording back to how it was, which I'll pull up.
I believe the original wording was a little.
It was a little clunky.
Yeah, it was a
and
little clunky, so
Yep,
we could
and-
probably improve on that.
I would hope we would, as opposed to going back. I guess I would want to make sure that we're changing it to a thing that, you know, for the most part, it is small parcels that this is an issue for. I don't know if it's still an issue if you had 2 acres or more. I don't know if this is necessarily an issue. If you're still within the side yard setback, you're 10 feet off the line. In Amber Oaks, that's a big deal. If you're on 2 acres, probably less of a deal. So I want to make sure that we're being thoughtful about all of the property, not just to change something for everybody because we have one issue.
I think that's a problem we need to be cognizant of too, because once we change one thing, it affects everything else. Which is why we're with your,
Understood,
right? So maybe we could make a cutout,
Like lots
Or-
3/4 an acre and under or something?
How about subdivisions that have an HOA?
Will comply with their
The
HOA
HOA's
rules, their
guidelines.
HOA rules?
Well, could we kind of put language in and make it say us or HOA, which is least restrictive? Cause it seems like you guys, your HOA is less restrictive than we are.
In the terms of what we're talking about with the setbacks, it is because of the issue it would cause. But we are fairly, I would say, more restrictive on the color, the other aesthetic values of
Yes.
of the idea.
But I'm talking about placement of accessory buildings.
Yeah, we're less restrictive because of the.
Yeah, yeah.
I like that idea better.
Well,
Well,
if
somehow
my
we-
HOA were to say you can build your sheds right on your property line, would the township then have a tool to supersede that? Because I'm on a private road, we have an association by requirement of the state to maintain the road.
I mean, so if we go down the road of, it's the HOAs, we're willing to essentially cede position of a shed on a property that's under an acre, that is in a subdivision with an HOA, that we're willing to follow the HOA's rules on placement, then I would say we just need a letter from them when you come in to say, hey, we want a shed and I want to put it here. Because it still says to get a permit, unless you're changing that, it still says to get a permit, so we still have to issue a permit. We would just probably need a letter saying the HOA is signed off on where they're saying they want to put it.
Which is what you have to get when you do that anyways, right?
They have to submit an art design, the art design is sent to the management company ensures that they're not in violation of anything, and sends it for board approval, and if there's an exception, for something in an art design, I'm just gonna use, somebody becomes disabled, needs a ramp, we don't really allow ramps in our HOA, but that's like an ADA or a HUD exception, so then we would go through and say, well, no, there's a reason or hardship here, so we would approve that.
Okay.
And that would suffice for you, Jonathan, would just be a letter?
I mean,
As a zoning
I would say
administrator?
we need something from the HOA. If we're gonna defer to their placement, then we would just need, the language has to say that, but then we would need something to indicate that the HOA is okay with it.
And we're all discussing just accessory structures that are under 200 square feet, not on a foundation?
I would like to leave it the way it is and then put the letter in there for the HOAs to address that particular issue. Would that work?
So,
Because we went
but
through
you're,
all
you're
this.
saying you don't care if it's on a foundation or not?
That's what his question is.
That would be up to the HOA, correct?
And the building department too.
Well, if it's under 200 square feet, we don't require anything.
Right, which is-
240 square feet,
Then there would be a
Then there's
permit
a-
required.
okay.
If it's under 200, which we're talking about right here.
I mean, I don't know how much square footage an HOA would allow. I guess it would all depend, but anything bigger than 200 is getting kind of large.
Yeah,
Ours is a
anything-
percentage of the house, isn't it?
I was just gonna say that it's a percentage of the house. And it's not a large percentage, it's
No, the
small, and we've approved the larger, but again, we're not gonna approve something ridiculous, because then that devalues the homes around, nobody wants to see a barn on a quarter acre next to a home.
So could you put a 10 by 20 shed in your backyard?
It all depends on what your square footage of the building is.
Technically, no, you cannot put a 10 by, with the percentage we have now, that would be too large for any of the homes that are within our HOA.
I want to say mine's a 10 by 10.
So,
Yeah.
So could we leave it as it is and then put language in there that would allow
Yes, and
an
that's all I wanted to
exception with a
confirm.
letter from an HOA, which would be sufficient to you? As a zoning administrator?
Well, it's just making sure that whoever's rule we're going by, so if we're not gonna follow the ordinance, then to me, you need something that says their HOA is okay with it. I don't wanna issue it saying, it goes here, I know it violates the ordinance, but you're under an acre, so just go check with your HOA. I'd prefer it the other way, which is, go to your HOA and tell them what you wanna do, bring us a letter that says they're okay with it, so then when I look through the ordinance and I say, as long as the HOA is okay with it, right, then I can do this. So I'm still following our ordinance, but I can prove it.
Just wanted to confirm.
Going back to cargo containers though, we took care of that one, correct? Alright, I noticed there were some strikeouts, like on page 8, it says containers shall not be stacked above the height of a single container, are we gonna allow stacking now?
So that was specifically to kind of address things like if there was a shipping yard. So we wanted to build in some other parameters here. Sorry, one second. I want to find where I'm thinking of.
Was that covered under section F4 with the height limitations?
Height limitations.
4,
It's,
must not exceed 15 feet when located in a front or side yard.
Yes.
Yeah.
Thank
and
you.
that's accessory buildings
Yes.
or structures, so if we're considering a cargo container
Yes.
an accessory building, that would apply.
So if it's in the rear yard, can it be higher than that?
Page 9.
No,
Because that only
container shall not be
covers-
stacked above the height of a single container.
Yeah, that seems to apply to front and side yard placement.
And then
Well, wait,
also,
previous page, 7E, no detached accessory can exceed 1 story or 20 feet. It's a little lower if it's on the front or side.
Are we looking on page 9,
Yeah, container shall.
Yeah, it's.
number 9? The
Yep.
first one says containers shall
not be stacked above the-
Thank you.
not be stacked above the height of a single
Yes.
container.
I was like, I know I wrote it in there
That's-
somewhere.
that's-
Residential.
Kind of
so
right
it
there.
just, you
It just moved. Yeah.
You just moved it? Okay.
Thank you.
And then the writing and the advertising is on there too? Okay.
Yep. Yep.
So if you have on any site, on page 6, it says any site containing more than 5 cargo containers. And then it talks about they shall be a similar neutral color, so if you have less than 5, they can,
As written, correct. Because at 5, they are going to need to come talk to you, I believe. But yeah, under 5, there's no restriction on that yet. And I believe that is because below 5 is typically going to be any residential use, which was likely going to be a single or 2 containers.
because this is for 1407, which is. Because when you start modifying them, and it starts modifying all your different sections.
Yeah.
That's kind of why we have to.
And we could say containing 3 or more, because on any other parcel, there's no more than 2 permitted.
Yeah, page 5A1 says the planning commission may approve an increased number of cargo containers if following conditions are met. And there's a short list there. What is that? Specific to a commercial? That's the IFZ.
Because that section, oh, that's IFZ.
Yeah.
So it's like I said, every section you have to go look pretty much and see what it affects. We talked a little bit about that last meeting, how,
So what I'm reading there is we could approve, up to 4 containers, and they wouldn't all need to be painted. Cause that's the requirement of the beige, gray, brown, tan, muted green is the next in line underneath.
but this is only for like industrial flex zone and.
Yes. Yeah.
Grace, in agricultural residential zoning is used in the farm, they can have as many as they want, right?
Yes.
Are they under the onus of having them a consistent color because they have more than 5 or not?
That should be added in. If you guys would like that as a requirement, which I presume because try to take that stance on the agriculture.
They can have them,
The-
but what we are deciding is whether we want them to be a consistent color,
Yeah.
if they have 10 of them.
If it's used for,
Under GAMS. It's gotta be used under, if you're talking about agricultural,
Yeah,
yeah, it has to be under the
yeah,
GAMS.
yeah, under GAMS. Otherwise, if it's just an agricultural district, no, they can only have 2.
So you have to be using it for a farming purpose, that's what the GAMS is.
okay, but do they have to be a consistent color? Do we want to have that?
I think it would depend on how they were laid out, right?
Yeah.
If it's an agricultural, they may be 4 or 5 acres apart,
Yeah, nobody
so.
will.
Did that carry over though, as far as no, like, I don't care on the farming thing, but if they're like all brown or whatever, but does that mean markings though? Are we still,
Yeah, I was
we're
just
saying
wondering
no,
the same
no
thing.
markings, right? We're not gonna,
It's in no graphics.
yeah, graphics, whatever you wanna call it.
Does that,
Yeah, that's
Yeah,
addressed,
That
yeah.
was in there.
Okay, so I have a farm and I have 6, as long as I don't have like
No,
company
yeah,
logos on them,
yeah,
we're all good.
no graphics
Okay,
or anything.
that's good, that's fair. Just to be clear, so if you have a farm, not a problem. But if you have a business that's visible in the community, that's where, to me, I think we owe the people that live here that it should look decent and clean and nice and uniform. That's my issue. And if it's visible and it's not going to be a screened-in fence, it's going to be a chain link fenced, that's visible to me. So that's where I think it is important that we have some kind of guidelines here. If you're popping down containers, that it is still appealing to the people that drive by or live in the township. That's my concern
No,
with
no,
this,
absolutely,
you
that's,
know.
that's precisely
Agreed.
it. And, you know, this graphics restriction applies moving forward too. You can't just take off the former shipping company's name
Right.
and put up Sharon's storage container park outside, right?
But by allowing more containers in the industrial area, we're requiring them to be consistent, one color. It's
Yep.
not unfair.
as long as they're over 5.
Yeah, you can
Yeah.
change that to
Yeah.
3. Is that then?
We can change that to 3.
Because that's gonna hit the recent applicant. I'm sure there's gonna be more than 3 and more than 5 there, so.
Yeah.
Yep.
Yeah, I don't think you really pushed back on that, so you got available things.
Uh-huh.
You just asked us what color, if I recall correctly.
Can I ask you guys, so on A, so I'm on page 5 still, where it kind of lays out exactly what we're looking at. So I can't remember what we discussed, but to me, if you paint them and make them look harmonious, we've used that word a lot, what does appropriately screened mean? To me, you're addressing the problem of what could be an eyesore by making them all uniform. But when it says D, all containers are appropriately screened and I get the access as far as driving and stuff, but what does appropriately screened mean?
Just that it meets the zoning ordinance's landscaping requirements.
Okay, so here I have my container down here. What is, I don't understand what,
Like, for instance, with the case that just come before you guys, you're saying that the landscaping did appropriately screen because you're saying that it met the zoning standards, but that's when you guys wanted to add the color to it.
yeah, it was the terminology that hit me, like this is all containers are appropriately screened. I didn't know what that means, like, oh, have a container, I
Yeah.
have to have a couple bushes, that's not,
No,
to
it's-
me, it's,
yeah.
okay, I just wanna be clear, as far as him, that basically what we're saying is you can have containers, but after a certain amount, you want them to look uniform.
Right,
Okay,
if there's
that's-
some
okay,
instances
okay,
where you
thanks for
don't
the
think it-
clarification, that was the only thing I thought, I don't want him to have to plant a bush behind every one
Right.
of them, so, okay, all right, thanks.
Okay, so did we want to change the requirement for, paint, matching paint from 5 to 3?
I think that's
That's
what
what I
think
heard.
that's,
Okay. Did we have any other, I mean, we had a bit of discussion, but I don't recall any other requested edits.
Not for this portion of it, but for the previous, where we were discussing residential. Which I think you, as a commission, would probably like to see that new language come back before you, before approval.
Yeah, I just think we wanna look at the next draft to ensure that what we're thinking is what we're seeing.
Mr. Chairman, then I would make a motion to postpone action on the proposed text amendment, so that the discussed changes can be made and then reviewed at the next meeting.
Thank you, sir. Motion from Mr. Newstead, do we have support?
I'll support that.
Support from Sharon. All in favor?
Aye.
Aye.
Thank you, sir. Motion passes. Okay, next up, we have our new business, which is none. Number 13 is our call to the public. Public, anybody wish to offer some input or commentary on this tonight, or?
I do have a question.
Sir, you want to step to the mic?
Yeah, absolutely. As far as the shed issue, taking the HOAs out, and to kind of maybe put a little bit of, not only question, but information out there, but what's the actual issue on the properties that are under an acre, under a half an acre, which we referred to as a fraction of an acre earlier, where you have the shed in the back? So if you take the HOA out and you have like a maintenance issue, like you wanna be able to cut the grass behind there so it doesn't become an eyesore, what if you guys considered like 3 foot, like the average deck width on a lawnmower, push mower is about 22 to 24 inches. As long as you get back there maintained so it doesn't become overgrown or unsightly or look like blight, what's the issue of like looking at that and saying like, come in, apply for the permit or let us know what you're doing and almost treat it like we do with our design, saying, oh, I don't see how you wouldn't be able to maintain it and you're still gonna have like appropriate use of your property. Does that make sense? So is there any like issue that where you're looking at storage containers, no, I'm sorry, I misspoke, the sheds, like the
Shed.
tough sheds, the Costco sheds, where you're infringing on your neighbor's property or the view or something of that nature? Because if they're under 200 square feet, they're really not unsightly, and they're not overly large. It's, they don't tower up like a silo, is I guess what I'm saying. So is there any particular concern on that originally, or that you guys can remember or think of?
I think originally, you could have put them right up to the property line. Though I'm not sure about the lot size requirement. I do remember Joe House speaking to that once, and yeah, right now, you can just put a shed wherever you want on your property, right along,
So
put
do
them
they
all on the
also
property line.
cover the portable Harbor Freight vinyl enclosures? That would cover, that would fall under something of this nature too, right? So
I mean,
you
I-
wouldn't
that's-
necessarily want it in the front yard, I guess, maybe?
No, not the front yard. We're just talking about the backyard.
He's talking about a shed.
He's
like
talking
a
about
shed.
it instead of,
Okay.
instead of
Shed.
deferring to the HOA, making it just a different standard, not to the setbacks of the ordinance, but some separate standard.
Which could apply to like
Maintenance
just
standard.
under 200 square feet without a foundation.
Yeah, and
'Cause
then
that's
probably
not
tie the
regulated.
lot size too, up, and we're gonna take away the setback requirements.
trying to put a shed in, going, wait a second. But, you know, I'm just thinking ahead, so if you approach it maybe from a lot size portion that you don't have, you know, Bobby Wentworth coming in here saying, I don't live in an HOA, why do they have special privilege in Lido, and, you know, I need storage for my lawnmower. And I don't know about you, but 2-car garages aren't the same as a 2-car garage used
You
to
betcha.
be.
I think that's a valid,
Yeah.
Good point for us to take a look at.
For a shed and a parcel under an acre. And that's where variance of the zoning, so.
And somebody's on 3 acres or 5 acres, most likely they're probably not gonna have a homeowners association, but you still have your out of them, the HOA giving you permission, giving the resident permission.
I think though what is saying is that there's neighborhoods that don't have HOAs but have smaller lots. We should probably be looking at a way to create word, language so that if I don't have an HOA but I wanna put we should be looking at a shed availability for people.
Well, there would be, it would just be the one that we have now.
Yeah, but
that's causing concerns with.
Right, but we're saying, yeah, bring your HOA paper in, and then we'll say like, okay, not a problem, here's your HOA, but what happens if people don't have an HOA?
Perfect example is we were talking about the gentleman with the tractor earlier that's on the violation list. He's under an acre, not an HOA. So the rule that we talked about today wouldn't apply to him. It would apply to Mr. Wentworth, but would not apply to the gentleman on Brewer.
Fix this problem, but we still have that problem. If you
Never
don't have an
mind, so.
HOA, then
But
you're
they could still go to the ZBA, right?
Yes.
There's still a route for them to try to get the township to agree to what they would like. And you guys have that option too.
That's a
Yeah,
lot of
it's
money.
horrible.
But-
And then you have to prove, I mean, you have to.
Yeah,
Yeah.
I would recommend against that.
I agree with what you guys are doing. I think the way we're thinking about it, if we're looking at other instances that maybe that's just the way it's gonna have to be on something that like the guy with the tractor, or somebody that has an acre but they're not in a HOA. I don't know how we could handle that.
Are
Well-
those size lots, they're not that common in the township, though, most of them are.
Common, no,
They do
but they do exist. Yeah.
And there may be more coming. So.
But in
More
the,
likely with an HOA.
but the situation with the tractor though, I consider that kind of like a grandfather. It's grandfathered in,
That's a
that's
special
different.
thing.
But I think that if I don't have an HOA and I wanna put a shed on my property, we should be looking at how those people will be able to do that, it's something,
Well, a residential area like that is 10 feet off the property line, correct?
Side for the side.
Side?
Yep. Rear's different based on your zoning.
so that's why you're saying maybe lot size, or, I don't know, I just think we should.
How big is the lot size in Amber Oaks? Just out of curiosity.
They're under a half acre.
Okay.
I would say that some of them struggle to be a quarter acre. It really depends on it. If you look like a cookie cutter neighborhood, like the ones more in the metropolitan area, where you got streets like this and streets like this, and they cross, and then every single house is the exact same acreage size. Ours kind of sweep around, and they have kind of a cookie cutter effect where they narrow in, and then you have the other houses that are more cookie cutter, and they have a little bit deeper backyard, but they have a narrow front, and they're more square. But yeah, I would say that half acres probably.
Maybe that's the biggest in there, but they're most probably a
Yeah.
Like
Three-
a lot
quarter to,
in the city hall, a standard is 66 by 132 feet is a standard lot like in the city hall. That's like a fifth of an acre. That's how they,
That's very similar to my lot.
Okay.
So I think that's a 12,000 square foot or something.
Yeah.
city, how they address this, the city lots?
I believe the city is the same one that you implemented with the 40-foot rule. And I don't think that's an issue because there's no new builds there and everybody there that has a shed was grandfathered in prior to, so. But my understanding is the city's got the 40-foot setback as well. I just don't think they've had anybody really challenge it because no one,
For accessory buildings?
just the shed.
I don't, that would be difficult to get in a lot that size.
Yes.
In the city, this is from my experience, I put a garage in probably 20 years ago and it was 3 feet from the property line. So I had to keep that garage 3 feet from, and it was a corner lot, 3 feet from the back and 3 feet from the side. The one kicker with the city is you also have to be 10 feet away from another structure. So if you wanna put a garage in and you go 3 feet into your property and your neighbor's got a garage that's 3 feet away, you gotta build 7 feet from it. That was another thing that I found, but I don't think we're gonna catch every circumstance, that we can look, we're just not gonna be able to catch every single thing. I think some of the more condensed subdivisions, what Jonathan is kind of proposing, so that he has the latitude to give you the permission to do that. It's already come under the scrutiny of a HOA. I like that. Somebody that's on a half acre or an acre that's on an HOA maybe is gonna have a different hardship, and I don't know how we can address that. Maybe we can look into it, but, you know, you've got, somebody that's on an acre has a lot more space than you or your neighbors. And, you know, that's why I think coming to the ZBA and maybe presenting a hardship that they have and ask for an exception is a different case, you know.
Yeah, it could be. I just wanna point back to, isn't that a $400 process to do? So then you're adding a third of the cost of that shed on there for people under an acre. I mean, I don't know about you, but if I put a $1,300 shed on there and it costs me an extra $400, you know, it puts a bit of a financial burden on the folks, especially in the township. You know, we got a lot of working class people, we got a lot of contractors, but, you know, we got farmers and whatnot as well, but, you know, I know that current economic times kind of strain that $400 process, even the knowing that there's no guarantee to it, so now I just spent $400 and I don't have a shed, so, I just wanted you to take that into consideration, you know, with what's going on. If there's any way I can help you going forward, John, I think you still have my number, if not, I can share it with you before I leave, and I'm willing to help kind of work through this kind of mental, problem as you guys go along. And I appreciate y'all doing this, number one. Number two, it's not easy. And, you know, you're never ever gonna meet every single thing, but to minimize the impact on the community, I guess is my thought. That's all.
Thank you.
Thank you.
Thank you. Anyone else care to step up? You're welcome to. It's an open mic. Okay. Close our call to the public and move to our final agenda item of adjournment. Do we have a motion?
So moved.
I'll support.
Mike?
Support.
Support from Robert, I'll give it to you. All in favor?
Aye.